Absolutely. From here, we'll now switch gears immediately to the next conversation. The ADC is in quote-unquote turmoil. They're talking about the issue of whether or not what the Court of Appeal pronouncement is 2-1 is a split decision of the Court of Appeal that emanated at the trial court, talking about state congresses that were conducted by the caretaker committee set up by the David Mark-led NWC. And the Court of Appeal has agreed with the trial court to say, look, you don't have the powers. And, well, one dissenting judgment is also there. However, we haven't seen the CTC, but what has been reported is what we're talking about. Now, let's bring in a senior advocate of Nigeria, Mr. Kayode Adiluola, who joins us virtually. And thank you so much, sir, for coming on the program.
Gordon, thank you very much for inviting me.
I think the argument always is what the court expressly says or what the court is saying by implication. So, from a learned mind, what is the court saying? So factually, the court said those congresses conducted by the David Mark-led group, they're invalid. That is what the appeal court has upheld as far as the trial court decision is concerned. But the members of the party are saying there is nothing in that judgment that says they, as NDC leadership led by David Mark, have now been nullified by the decision of court. So where do we stand as far as the David Mark leadership is concerned based on this decision of the court?
Well, for David Mark, the question has always been whether they were properly constituted as the leadership of ADC. And also, don't forget also one of the things the court had to consider was whether or not the caretaker committees in the respective states would have been set up by David Mark, and whether they could have conducted the primaries in those states. Now, one thing was bear in mind that every political party has a constitution, and a constitution of a political party is an important and live document of that political party. It's an important document to submit when the party is going to be registered with INEC. Therefore, no political party can, of its own volition, decide to flout those orders or those sections or the guidelines or the provisions of their own constitution. Now, what has happened is that David Mark led ADC has said that, well, we have constituted a body, but what we find is that in that decision of the Court of Appeal, the minority decision I will speak on right now says that what has happened in ADC was an internal issue, and therefore was not even something that the political party that the court could come into. So the truth is, was that an internal dispute? Was it something that the courts could entertain? That minority decision felt that it was an internal dispute, and so ab initio, the trial court itself had no jurisdiction to even entertain it. So that is a technical point, and I am of the view that political parties must begin to look at every provision of the Constitution, the Electoral Act, their Constitution, and see how to ensure that these provisions are complied with. But as it is now, the David Mark-led exco of the party, well, as it seems, they are still in place, but there are some acts that they cannot and do not have the power to do. They cannot appoint caretaker committees where there should be congresses in the respective states.
And so to follow up on Jeffrey's question, the more important question, relatedly, just as important rather, would be that what did the court expressly say? Did it say that the congresses were not properly constituted? Or did it say that INEC shouldn't, did it order INEC not to recognize the David Mark-led group? Because those two are different things entirely. Because there are reports saying that what the court ordered, the appeal court order, is that INEC should not recognize the David Mark-led leadership. So from your standpoint as a legal practitioner looking at that judgment, what did it expressly say?
Well, I'm yet to see a certified true copy of that judgment. So what I'm saying is what I have gleaned from the reports. But I would have loved as a legal practitioner to have the opportunity of reading the judgment myself, to interpret it, and to be able to make an informed opinion about it. But what I gather is that what the court has said now, that the David Mark-led ADC has in place David Mark's EXCO, the National Working Committee, but there are things that it had no authority to do. So if it had set up caretaker committees in places where there should be congresses, then those acts of those congresses cannot be in line with our constitution, cannot be in line with the constitution of the political party. And as such, INEC cannot be invited to monitor or supervise primary elections held under the guidance and supervision of caretaker committees rather than congresses as provided for by law and constitution of the political party.
I'm looking at the provisions of their own constitution. I'm looking at Article 19 of their constitution that when it came to the part of the NWC. So I'm trying to make sense of what the court is saying generally, because I know that according to the Article 19, that has to do sub 12, that has to do with the NWC, and further sub says that somewhere around there, the NWC be empowered to dissolve any state executive and constitute an interim or caretaker committee as NWC may consider necessary. So the argument the gentleman who took about 7 of them out of the 36 who took this case to court was to the effect that their tenure had not elapsed. That's on one hand. 2, that state congresses has to be conducted by the state itself, not caretaker committee from the national. And so they approached the court at the trial court. The trial court agreed with them, which has now been upheld by the Court of Appeal. So if the NWC has certain powers, just like I've read now, and then the appeal court and the trial court are agreeing to say, you as NWC, you cannot conduct an election at that subnational level, doesn't that invalidate the NWC itself? Or is an overreach, or it has to be expressly stated?
Now, you see, the NWC has its authority, has its powers. But by the same token, the state EXCOs also have the authority, because the EXCOs are the ones empowered to set up election committees in their respective states, where the congresses can then take place. All right, and then the primary elections can take place. But the National Working Committee must be one that has been validly put in place. There cannot be a caretaker committee, for example, because the constitution does not provide for caretaker unless they have, of course, a clear exigency. Now, the these gentlemen who have taken the ADC to court are saying that they have a term of 4 years in the first instance and another 4 years after that. And unless those terms have been exhausted, or there is good reason, they must be allowed to conclude their term of office. So if you have not allowed them to do so, on what basis? Because, see, in our democracy, we must ensure that constitutional provisions are adhered to, and we do not allow them to be subject to the whims and caprices of individuals, no matter how highly placed they may be.
Let's say so. But you said something about maybe the premise, but I just read here Article 19 of their constitution that is available to me, except they've updated it. Article 19, sub 12, this Roman numeral of, I think, this should be 11, that the NWC, that's the National Working Committee,
yes.
The National Working Committee shall, I go down to that number that says, be empowered to dissolve any state executive and constitute an interim or caretaker committee as the NWC may consider necessary. So is it a question of, because here clearly says they can form interim or caretaker committee. But so the argument will now be, if it is in their constitution, is it how it was done that is a problem?
I would believe so. Now, because see, if the constitution gives them power to dissolve and constitute caretaker committees, as may be necessary. The question would then be, how do you determine as may be necessary? That should be something that will come before the courts and determined by the courts, and to determine, so that you do not have a situation where there is high-handedness or parties now feel that, well, once somebody is chairman of the party or a member of the National Working Committee, they can wake up at the wrong side of the bed and without any good reason say that, well, we have every right to dissolve this these congresses or committees in the response, and that they do so without good reason, as may be necessary.
Senior Advocate, doesn't the phrase "as may be necessary" then point to the internal workings of the party at the discretion of the leadership of the party? Hence the split decision that it's an internal party affair. Hence the trial court and even the appeal court bear no jurisdiction over it.
Yes, if we look at the issue about internal disputes of a political party and Section 83, I think, of the Electoral Act, saying that the courts are not having jurisdiction to entertain issues about internal issues of the political parties. Well, those are matters also that will be determined on a case-by-case basis. If, for example, in an internal situation of a party, a man who wins the primaries is set aside, that's barely an internal wrangling. It will be a breach of democratic principles and the Constitution. However, if what you're saying is that determining whether you can dissolve a board or an exco committee in a state as may be necessary is an internal, but then it would mean that we are, without realizing it, giving such draconian powers to the National Working Committee, who can determine we don't like these people at this electoral committee or Congress or the exco of the state, and we're going to dissolve them. How do you determine what is necessary? That might be something, as I said, for the courts to interpret.
But let's then relate it with, another political party, a certain individual who had an even more valid case in line with what the Electoral Act stipulates about the exceptions where, disputes have to do with exclusion or a nomination process. I believe Dagogo, who headed to court, but the court threw out his case. Now, when you look at this, isn't that even more draconian in the outlook of the court's decision over that particular matter, as against this that bears more semblance with an internal affair of a political party?
Well, for me as a legal practitioner, one thing we have learned is that courts decide cases based upon how these cases are presented before them, what the arguments for and against are before them. And so that's why we cannot put arguments in a computer and come up with a decision. It's not unlikely that by sheer force of argument of the counsel, you're able to convince the court that this is a situation where an internal dispute has arisen, therefore your lordships cannot interfere. Whereas there's some other situations where a counsel can also convince the court that this is a situation where it does not apply. And that is why when such arguments come forth, someone may be able to bring to the fore provisions of the Constitution, for example, where you're talking about direct primaries or indirect primaries and censors or what have you. And an individual like Dagogo Jack, whom you mentioned, may be able to approach the court and say, not only have I been denied, but the Constitution also has been flouted. That situation, so in such a situation, the court will have no option but to uphold the provision of the Constitution in his favor.
It's tricky.
We all have to agree that we are in a learning process, and many of these things will be determined. But the truth is, I think political parties, politicians also must engage their lawyers, have seminars on the provisions as they apply to them, so we don't keep having these hiccups. There are many provisions in the Constitution also that a lot of people are unaware of. I think there's a section 225, for example, that says that you cannot even have funds coming from overseas into Nigeria for your political campaigns. But a lot of political parties are receiving funds from overseas. So one day somebody's going to say that you can't do that, and you must transfer the funds to INEC. If such a situation arises, a lot of people are going to say, oh, but we did it in 2023, or people brought in funds in 2027, oh, now why are you complaining now? So we need to sit down and look at the provisions of the laws guiding us, and not just act ad hoc or on spur of the moment.
Interesting, Senior Advocate. We can go on and on, because we've seen similar, just like my colleague Bukola has said, a similar situation. In fact, it has to do with nomination. And you see two different judges. One stays out and says, look, this is purely internal affairs of a political party. And then literally the same thing. Another political party, it says, no, we can intervene on this one. Found a way. So I don't know whether the problem is with the courts or the litigants. I'm not sure where the problem. But because we're building democracy here, and when we have almost the same case, I think I'm trying to remember the other case now. I know that the Dagogo case from I think that should be, yes, I remember now. The Dagogo case from APC and the Sule Lamide case from PDP were literally similar. It was about, I want to contest. Allow me to contest. I do not agree to consensus. And one court says, it's okay. Your party has said, no problem. If you should stay out of it, stay out of it. The other one said, no, your party was wrong. They must allow you to contest. And he went all the way to the Supreme Court. So sometimes, where is the problem? Are courts giving varying interpretation to the same set of laws? Or what exactly is going on here?
I think some of the provisions in our laws are not robust enough to take care of situations that we can anticipate. I think, for example, if you're talking about political parties and internal wranglings and what have you, I think there should be subsections, subparagraphs, so that we take into consideration things that we can anticipate and see how we can see if some of them are sui generis, and say, for example, that, well, if you're talking about consensus or you're talking about direct primaries, it is clear that we already have provisions concerning them. But how do you determine, for example, in some institution of consensus, where all aspirants must agree that we want to have a consensus? But if we don't have that, then one person, even out of 5, should have the right to approach a court, and the court shouldn't simply say, look, your political party has reported to us that they have taken a decision that it's going to be a consensus, and then they just go home. So we need to have, but as I said, we're in the process, and with time, a culture will emerge, and we shall all know, without even looking at the provisions of the law, so to speak, to determine what really and truly should be and what should obtain. And I think we'll get there. It might just take a while.
Well, I know you noted that you haven't seen the CTC of this particular appeal court judgment, but from what you have been able to glean from what has been reported, what does this mean for the ADC's participation in the 2027 elections, broadly speaking?
Broadly speaking, I think it's ominous, because ADC still has to have its congresses, must still have its primaries, must send the list of their candidates, must send the list of their members, and whose responsibility would these be? They must ensure also it's the deadline, which is I think 150 days before the elections take place. Now, this is not only about ADC. This is about Nigeria. We cannot have an election where, and I've said this before on this panel, we cannot have an election where we don't have options for people to choose from. We must have political parties who are able to participate in elections, whether it's APC, NDC, whatever. But then again, we have a responsibility to uphold the laws. I do sympathize with our judges. Sometimes some of these things come before them. They know what the outcomes likely to be. They know what the sentiments are of the election. They know what the sentiments are for the politicians. So they have a responsibility and the clear provisions thereof.
Senior Advocate, thank you so much. We'll continue to look at this entire thing. Some of us have begged them, all the political power, we're literally begging the judges, the courts, the politicians, please, all of these litigations, can it just end in July? So we face real issues from August when the we're getting close to campaign season. So and that's the kind of questions we want to ask. Not every day we're talking about who is leading, who is not leading. Very mundane, juvenile issue after almost 30 years of our democracy. It's very painful. But almost thank you. Kayode Adelola is a senior advocate of Nigeria. Thank you, sir, for coming on the program.
Thank you very much.